Here are 8 common costly mistakes and how you can avoid them. Number 1, tell your medical providers everything that hurts. Your medical records are one of the most critical pieces of evidence in your personal injury case. Your medical providers are supposed to keep accurate and detailed records. These records include your description of how you were hurt, your physical complaints, your injuries, the doctor's examinations, and the treatment you received. If you fail to tell the doctor everything that hurts, not only will you not be treated properly, but you will likely receive a lower offer from the insurance company because they use your medical records to evaluate your case. If you first begin to complain about a problem weeks or even months after you were hurt, the insurance company will likely claim that the problem was not caused by the accident and reduce their settlement offer to you. Along the same lines, insurance companies will sometimes hire private investigators to conduct videotape surveillance of you. If you tell your doctors that you cannot run, climb, or lift, but you get caught by a private investigator who videotapes you doing these activities, then this can be very damaging to your case. Number 2, continue to treat if you are having problems. If you are still having problems caused by your personal injury accident and fail to see a physician regularly, then in the eyes of the insurance company, and eventually perhaps to a judge or jury, you must have made a full recovery. While you should not go to the doctor every day, you need to see your doctors and tell them if you are still having problems. If your doctor says follow-up is needed, then this means if you continue to have problems in a few weeks, then you should get back in to see your doctor. Number 3, do what your medical providers tell you to. If your doctors tell you that you should go to physical therapy 3 days a week, but you only go once a week, you will damage your case. Along the same lines, if your physical therapist tells you to do home exercises, but you do not, this will also damage your case. The insurance company, and perhaps eventually a jury, will blame you for not doing what your medical providers told you to do. Number 4, you need to be careful about what you say. The insurance company and their lawyers will use anything and everything they can to ruin your credibility. For example, if you tell your medical providers that you were hit going 55 miles per hour and the accident report says 20 miles per hour, they will use this to make you look like you are lying or exaggerating things. No matter what, do not exaggerate your injuries about your accident or lie. Even a small lie can ruin your credibility and cost you thousands of dollars. Number 5, the internet, social media, and Facebook. These are all things that the insurance company and their attorneys will use in an attempt to discredit you and your case. We recommend to our clients that they disable, but not destroy, all social media sites that they have while their personal injury matter is pending, and provide them with instructions about how to do this. We recommend this because if a lawsuit is filed, you will probably be required to provide Facebook and other social media pages to the other side in your case. Evidence from Facebook and other social media pages has been admitted in court and used against people. Nowadays, insurance company lawyers and their staff will try to find information about you on the internet which can hurt your case. For example, if pictures are posted of you smiling and having a good time after a personal injury, the defense attorney will show the judge or jury the pictures and argue, does the plaintiff look like they are in pain and cannot work in these pictures? While the picture may be a short time period where you are living your life, it can damage your credibility and your case. Number 6, keep track of your lost wages and how you feel. It's a good idea to write down every few days, or more often if you like, how you are feeling about your injury. This will help you later on provide accurate information about your injuries and how they affected your ability to function on a daily basis. Also, keep track of the time you miss from work and copies of doctor's excuses. Most of the time, the doctors do not keep your work excuses, so if you turn it into your employer and it is lost, this can damage your case. Number 7, be upfront with your medical providers about prior accidents and injuries. It goes without saying, but you need to be upfront and honest with your medical providers and your attorney about any injuries or accidents that occurred before or after the accident at issue. Keep in mind that the insurance company and their lawyers will gather all of your prior medical records, and if you deny a prior accident to your doctors, then this can hurt your case. If you have had prior injuries and accidents, then your attorney can deal with those issues, but your attorney cannot help you if they do not know about them. Trying to hide prior injuries or accidents can severely damage your case. Number 8, do not just sign any document the insurance company sends to you. It is very important that you read and understand what you are signing. We have had clients come to us who did not understand what they were signing and accidentally signed a release of their claim. We had to tell them that they agreed to settle their case for a small amount of money, and we were not able to help them. If you have a question about what you are signing, then you should consult with a qualified personal injury attorney before agreeing to sign anything.